Hello, and thanks for tuning in to Compass Media. I'm your host, Finbar Markey. On the 25th of July 2022, the President of Ireland, Michael D. Higgins, signed into law the Electoral Reform Act 2022. The Act passed through the Dáil and the Shannon, the Irish Parliament, with little to no public debate. It was also wholeheartedly supported by the main opposition party, Sinn Féin. The Act introduces sweeping changes to how elections in the Irish Republic proceed, especially with regard to the information that online platforms can display, including the monitoring for misinformation, disinformation, and inauthentic behaviour. The Electoral Reform Act 2022 creates potentially harmful powers, enabling the state to censor discussions and debates during an election or referendum period, as well as making it illegal to question the outcome of an election based on procedures. The fact that there was little robust debate on the electoral reforms and the fact that Ireland's main opposition party supports the changes indicates that Irish democracy is in a wretched state at the moment. Over the next few minutes, we're going to examine some of the main changes introduced by the Electoral Reform Act of 2022. Okay, so if we start off at the beginning of the Act and the changes that it makes with regards to registering a political party. If we look at section 45B, the party has not less than 300 recorded members, or in the case of a party applying for registration as a party organised to contest elections in part of the state or local elections, only 100 recorded members, each of whom has reached the age of 18. And at least 50% of recorded members are registered in the electoral register. Here's the second part. The party has at least one member who, at the time of the application for registration, is a member of Dáil Éireann or is a representative in the European Parliament, and who certifies in writing to the registrar that he or she is a member of the party. And then there are different criteria in terms of numbers for if you want to register for local elections. There seems to be a significant change here because up until recently, you could either have 300 recorded members or you could have one elected member of parliament. Now there is no or, and it seems to be that you both have to have 300 recorded members and also have to have an elected member of parliament before you can register as a political party. The or is not there anymore. Now, if you go on to the Citizens Advice Bureau, you'll find that that or is still there, but it's not obvious in the Electoral Reform Act 2022. Moving on to definitions then. Disinformation for the purpose of the Act means any false or misleading online electoral information that may cause public harm or, by reason of the nature and character of its content, context, or any other relevant circumstances, gives rise to the inference that it was created or disseminated in order to deceive. So that's the definition of disinformation in the Electoral Reform Act 2022. Very flexible definition. Manipulative or inauthentic behavior means tactics, techniques, or procedures that A, constitute the deceptive use of services or features provided by an online platform, including user conduct having the object of artificially amplifying the reach or perceived public support of particular content. B, are likely to influence the information visible to other users of that platform. Or C, by reason of their nature and character, context, or any other relevant circumstances, give rise to the inference that they are intended to result in the dissemination, publication, or increased circulation of false or misleading online electoral information. And D, may cause public harm. So that's the definition of manipulative or inauthentic behavior. Misinformation for the purposes of this Act means any false or misleading online electoral process information that may cause public harm, whether or not the information was created or disseminated with knowledge of its falsity or misleading nature or with any intention to cause such harm. Online electoral information means any online electoral process information, or B, any online content relating to a candidate in an election, a political party that has candidates standing in an election, issues that are of relevance to an election, or issues that are of relevance to a referendum. online electoral information, disinformation, misinformation, and manipulative or inauthentic behaviour functions. So this is the function of the Electoral Commission with regards to misinformation, disinformation, and inauthentic behaviour. 145. The Commission shall protect the fairness and integrity of elections and referendums in accordance with this part. B. Monitor, investigate, and combat the dissemination of disinformation and misinformation. C. Monitor, investigate, identify, and combat manipulative or inauthentic behaviour. D. Monitor, investigate, and identify trends in respect of disinformation, misinformation, and manipulative or inauthentic behaviour. E. Promote public awareness of misinformation, disinformation, and manipulative or inauthentic behaviour, and it may establish, facilitate, or promote educational or information programs for the purpose of the performance of its function. 2. Without prejudice to Section 16, the Commission may engage any person to assist it in the performance of its functions under subsection 1, and for that purpose, it may do so or any of the following. Enter into a contract. So this allows the state to hire private companies, what have become known as fact-checking companies, into the future. Establishment and role of advisory board. 146. The Commission shall establish an online electoral information advisory board to be known as the Advisory Board. The Advisory Board shall, on request and, if appropriate by its own motion, provide advice to the Commission on the nature and effect of disinformation and misinformation, and, where practicable, on the use by the Commission of its powers under this part. The Advisory Board shall comprise of no more than 6 persons to be appointed by the Commission, each of whom shall have expertise in all or any of the following: electoral processes, promoting fairness and integrity in elections and referendums, or the use of information technology and online dissemination of information in the context of elections and referendums. The obligations on online platforms in relation to notification mechanism. An online platform shall put mechanisms in place to allow any individual, entity, or person to notify it of the presence on the platform of information that the individual or entity considers to be disinformation or misinformation. An online platform should put mechanisms in place to allow any individual, entity, or person to notify it of the presence on their service of specific activities or behaviours in respect of online electoral information that the individual or entity considers may amount to manipulative or inauthentic behaviour. The mechanisms provided for under subsection 1 and 2 shall be accessible, user-friendly, and shall allow for the submission of notifications referred to in those subsections exclusively by electronic means. An online platform shall, without undue delay, assess, process, and determine the validity of the concerns raised by notices received. An online platform shall maintain a record of all notifications received under subsection 1 or 2 and the outcome of the determination referred to in subsection 4 for a period of 2 years following the end of the election period. An online platform shall make the records referred to available to the Commission for inspection on reasonable notice. Establishment and role of a stakeholder council. The Commission shall, from time to time, establish a stakeholder council to provide advice and opinions to the Commission generally and in relation to the preparation and use of codes of conduct under Chapter 5. The Stakeholder Council shall comprise not more than 15 persons to be appointed by the Commission. The composition shall reflect the views of members of the Oireachtas, as well as those of print, broadcast, and online media. So this stakeholder council is to maintain the status quo, obviously. Those who are already elected and the corporate and state media are the ones who will determine the outcomes of deliberations by the stakeholder council. So clearly this is to keep things as they are and try to prevent change. Monitoring and investigation of online electoral information. The Commission may, for the purpose of performing its functions under this part, monitor online electoral information, where the Commission reasonably believes that any online electoral information may constitute disinformation, constitute misinformation, or involve manipulative or inauthentic behaviour, including the use of undisclosed bots. The Commission or a member of staff of the Commission may examine or investigate or appoint an authorised officer to examine or investigate any such matters, and the authorised officer or member of staff shall, following its investigation, furnish a report to the Commission. The Commission or members of staff of the Commission may take such inquiries as it considers appropriate or direct an authorised officer to make such inquiries. And the Commission, member of staff of the Commission or authorised officer may require any person to furnish without delay any information, document or thing in the possession of procurement of that person that the Commission, member of staff of the Commission or authorised officer may require for the purpose of an investigation. Following the Commission's consideration of the report referred to in subsection 6 and any submissions referred to in subsection 6 and 7, the Commission may A. Take no further action, B. If it's established that a contravention is taking place or has taken place, exercise any of the powers available to it under section 153 to 157 with respect to any person whom the Commission considers is contravening or has contravened any provision of this part. C. Prepare and publish a report of its investigations into the matter. And D. If it's satisfied that a contravention is taking or has taken place, prosecute any offence that may have been committed in accordance with section 169. Exercise of powers of the Commission continued. The Commission shall only exercise its powers where the Commission is satisfied that it is in the public interest to do so, having regard to all the circumstances, including the rights of any person whom the Commission considers to be affected by the exercise of such powers. Without prejudice to subsection 1, the Commission shall, in considering the exercise of its powers, give due weight to the following matters: the right to freedom of expression, the right to freedom of association, the right to participate in public affairs, and the obligation on the state to defend and secure the fairness and integrity of elections and referendums. Without prejudice to subsection 1 and 2, the Commission shall, in considering the exercise of its power, with having regard to the following matters: the need to ensure the economic and efficient use of the Commission's resources, the public harm concerned as it relates to the overall integrity and fairness of the election or referendum, and any guidelines published under subsection 4. And if the Commission is satisfied that the issuing of such a notice is necessary to protect the fairness or integrity of the election or referendum, the Commission may issue a takedown notice requiring any natural or legal person, including any online platform, to remove within a specified period the content to which the takedown notice relates. And the Commission is satisfied that the issuing of such a notice is necessary to protect the fairness or integrity of the election and referendum, he or she may issue a correction notice requiring any natural or legal person to whom it is directed, including any online platform, to communicate to all persons who access the online platform a statement by the Commission under this section. C. During an election campaign period, if the Commission is satisfied from the information available that bot activity that constitutes manipulative or inauthentic behaviour or the use of an undisclosed bot contrary to section 167 is taking or has taken place at a previously identified online location, the Commission is satisfied that the issuing of such an order is necessary to protect the fairness and integrity of the election or referendum, the Commission may issue an access blocking order for such a period as the Commission considers appropriate, requiring any online platform to take reasonable steps to disable access to that online platform. And so it is now an offence to not comply with the orders sent out by the Electoral Commission. So 165, offence of failing to comply with notice or order issued under sections 153 to 157. It shall be an offence for any person to fail to comply with any notice or order, whether that notice or order is addressed to a person within or outside the state. A person found guilty of an offence under this section shall be liable, A, on summary conviction, in other words, if you don't put up a defence, to a Class A fine or to imprisonment for a term not exceeding 12 months or to both, or B, on conviction on indictment, so this is where you do defend yourself, to a fine or to imprisonment for a term not exceeding 5 years or to both. So that's the Electoral Reform Act 2022 in a nutshell, or at least some of the major changes. The changes do seem to be focused on information about the procedures of an election. And in that regards, it does seem to be focused on what happened in the United States in 2021 with the US elections there. However, some of it seems quite ambiguous and flexible. And I am concerned it could be applied to general information, whether it's general information under discussion during a referendum or general information under discussion during an election. It's about waiting to see how these new laws are going to be applied into the near future. We'll watch this space and see. Thanks for tuning in, folks. Please like and share.